Okay. Welcome everyone to the final two sessions of our workshop on climate justice in the Global South, and it is my privilege and honor this afternoon to welcome Professor Dr. Patricia Kameri-Mbote. Patricia is one of the most accomplished lawyers that I know. Okay, so she has served as Dean for the Nairobi University School of Law several times. She has trained judges and members of parliament and other professors at Nairobi Law School, one of the oldest law schools in Africa and one of the biggest in the world. She has served on various boards, such as the Global Council of Water and Sanitation, the International Development Law Organization, Advocates Coalition for Development and Environment, as well as the Kenya Land Conservation Trust. She led the efforts to establish a law school at Strathmore University, and that law school is now in operation and has been graduating lawyers for the past couple of years. She's also a founding research director of the International Environmental Law Research Center in Geneva, and its program director for Africa. I could go on and on, but it is my privilege this afternoon to invite Professor Patricia to our workshop. My friend, welcome. I now yield the floor to you.
Thank you very much, Toko, and for a generous introduction. And I'm very sorry that I couldn't be with you this morning. I had a whole morning of legal aid awareness. I would have wanted to listen to those who spoke before me, but that wasn't to be. So this afternoon, my task is to talk to you about climate change, tackling climate change in the Global South through international law, advocacy, and litigation. When one names the three of them separately, you might be tempted to think that they operate in isolation, but they don't. Actually, advocacy, litigation, international law feed on each other. So what I'll do is introduce my short lecture. And if you have any questions, I believe you can raise them in the chat. I will not talk too much about the impacts of climate change in the Global South. I'll then talk about the different ways in which the Global South has attempted to tackle this challenge using international law, advocacy, and litigation, and then I will conclude. I don't think it can be repeated enough that climate change poses a major threat to the Global South. And if unchecked, actually, it's a major obstacle to poverty reduction, to peace and security. And many countries in the Global South, and here I'm a lot familiar with countries in Africa, are very vulnerable to climate change because of their geography, their low incomes, and the fact that very many of them rely on climate sensitive sectors. As if that wasn't enough, the impacts on these countries are actually proportionally greater, whilst their ability to adapt is really not much. Because they are struggling to meet day-to-day needs of their people, so they don't really have a lot of cushions against shocks that come with climate change. Many are already struggling to cope with current climate. In fact, many countries in the global south, they are the ones that face the typhoons, they are the ones that have the cyclical droughts, and all those actually mean that at any given time, they're dealing with disasters, which costs can be very high, and therefore remove their capacity to adapt to a changing climate. Climate change in this context then amplifies all the other impacts that are there. So when you look at what impacts are we talking about, natural resources, many people in the global south rely directly on natural resources. They rely on agriculture. And so degradation of land and natural resources leads to reduced incomes, as well as depreciated or degraded livelihoods. You also have increases in diseases. And all these, again, you have to take into the context that I talked about, of the fact that they don't have cushions and their capacity to adapt is limited. Climate change actually has direct impacts on health when we're talking about the increase in disease vectors, incidence, transmission, and burden. But also, the impacts on agriculture could mean that you have malnutrition, but also immunity is compromised. People's immunity is compromised, again, leading to health issues. Many countries in the global south are experiencing higher population growth rates than others. In other parts of the world. And in many countries, you also have the phenomenon of people moving into urban areas, which are not able to cope with the big influxes. So you have many having informal settlements, and informal settlements bring their own set of problems. So in essence then, climate change means that countries really are running against a current. There is also the fact that the deterioration in climate leads sometimes to migrations. People may be moving from places that are flooded, or they may be moving from places that are dry. And those migrations occasion problems, but they could also lead to conflicts. In fact, in many parts of Africa especially, climate change has been seen as both a source of conflict, but as a sustainer of conflict as well. And when we talk about migration, people move within their country, but they could also move outside of their countries. And this can also bring conflicts with the people that they find. In fact, in many parts of Africa, which has quite a number of refugee camps, the receiving populations many times complain about the fact that the refugees probably get better attention than them, because they have the international humanitarian organizations looking after them. Climate change doesn't affect everybody in the same way. Where people depend on land and natural resources, the roles that men and women play can mean that the impacts of climate change are gendered. And so one has again to think about the impacts that climate change has on the young, men and women, on elderly men and women, and on disabled men and women. So given that the magnitude then of the problem and the different manifestations of climate change, there's need for a multifaceted approach in addressing it. And we have, I think from 1992, UNFCCC, the United Nations Framework Convention on Climate Change. We have a very robust international framework for addressing climate change. And this has found its way into regional and national laws and policies. And because climate change happens at the place where people live, people have also put interventions at the local level. And the governance norms, the norms that people put in place to govern their environment, many times also help in mitigating climate change, as well as facilitating adaptation to climate change. And when we're talking about environmental governance norms, there will be those that deal with the substance of environmental rights, as well as those that deal with processes, the access to justice, access to information, involvement of people. Countries in the global south are parties to these, to international and regional treaties, and actually have brought this down to the national levels. If you look at how climate change is being tackled in international law, right from the UNFCCC to the Paris Agreement, when you look from 1992 to 2015 and moving forward, one can see a pathway being created for tackling climate change. But it is not only the climate change specific agreements and treaties that help to address climate change. There are also other treaties. For instance, the United Nations Convention to Combat Desertification. Under that convention, there is the quest to ensure land degradation neutrality, which means that whatever actions are taken on land should not affect the state of the land, because land and soil are actually the biggest reservoirs of carbon. So land degradation neutrality under desertification is a critical intervention for addressing climate change. And basically you look at these international treaties and how they are taken on at the national level. Many of our countries probably require ratification. Some have provisions in their constitutions that provide that international law directly applies once a state has ratified such international agreement. Another regime that is relevant for climate change is biodiversity. Again, forests are a big reservoir of carbon. And so the Convention on Biological Diversity and actions under it, whether you're talking about regional safe biodiversity strategies and action plans, or national biodiversity strategies and action plans, and the measures taken to conserve forests, all these are going to help countries deal with climate change. In fact, if you look at the nationally determined contributions under the Paris Agreement that countries have committed to, they cut across. You're talking about transport, agriculture, energy, forestry, livestock and fisheries, to name a few. So in essence, international law starts at that point, but catalyzes a set of actions regionally and also nationally. And these sometimes go down to the local levels. And it's not just governmental actors that are involved. I think climate change is one area where actions by private sector actors are very critical, because the governments are only operative in particular spaces, but private sector actors are the ones in transport, in manufacturing, etc., where you can actually take actions to ensure that there is no emission of greenhouse gases. And this can help countries meet their international commitments under the nationally determined contributions. I think it would be not right to move from international law without talking about the importance of research. The Intergovernmental Panel on Climate Change has periodically issued reports, which are actually very useful. First of all, because they're done by scientists, and here not just natural scientists, you have also social scientists, and they help to get people to know what are the problems, and also to help map what innovation is required. International law also lays the basis for partnerships. And if you look at the Sustainable Development Goals, many of its goals actually touch on climate change, but it puts a premium on partnerships. And those partnerships are important because climate change affects all of us. So there is what is called an issue of common concern, but also all countries have a common but differentiated responsibility to stem climate change. There is also the requirement to cooperate by sharing resources as well as technology transfer to reduce emissions. So moving then to advocacy for climate change. I think advocacy for climate change can be through, you can use international law to advocate by, for instance, there was this one movie by the former vice president of the US, where you use scientific facts to actually get people to appreciate the gravity of the issue. But you could also use you can use art, you can use messaging, you can use different media. I think in many countries in the global south, where you have more than one law operating, where for instance you have religious law, customary law, you have a greater diversity of tools to use to deal with climate change. But beyond the multiple advocacy strategies and the alliances that these demand, countries in the global south have also increasingly used litigation. And I think litigation can also be a way of advocating, because it does bring attention to focus on climate change. So why climate change litigation? I think if you talked about climate change litigation, let's say 20 years ago, people would have wondered what one was talking about. But increasingly, the dramatic impact of human activities on the climate have led to people looking for different ways of addressing the problem. And litigants who go to court on climate change litigation seek to compel their governments to have more ambitious mitigation and adaptation. So they want the governments and private parties to be more ambitious. So you'll have cases seeking to accelerate efforts to implement emissions reduction targets, or to attain ambitious national greenhouse gas emission reduction goals, or connect harms suffered by vulnerable communities to people who have emitted greenhouse gases. You will also have people bringing actions to get global climate change concerns to bear on local action. And this is where I was saying that the advocacy strategies, whatever is happening at the national level, at the international level, does influence what happens at the national level. They could also seek to force adaptation action or recover damages that result from others' failure to adapt. So in essence then, climate change litigation can enhance actions to meet goals that have been set. It can promote climate regulation. It can spur reforms to environment impact assessment processes, to planning processes and other procedures. It could also promote investments in social and physical infrastructure. And in some instances, climate change litigation has delayed or stopped proposed projects, as we will see. So what is climate change litigation? I think when one talks about litigating for the climate, one wonders, how does climate change litigation look like? And the answer to what is climate change litigation is that climate change litigation presents in a diverse array of options. So there'll be cases that raise material issues of law or fact that relate to climate change mitigation, adaptation, or science of climate change. And these are brought either before administrative tribunals, courts, or other adjudicatory bodies. And in essence, what one is seeking is to get the issue that is either continuing climate change or catalyzing climate change dealt with. So in essence, the litigation that has come so far takes the form of whether people may go to court to enforce what are called climate rights, and I'll look at those in a moment. They could also go to court to get domestic enforcement. And I think in countries where there is a progressive law, but lethargy in action, courts can be a space where you can go to get domestic enforcement. In other instances, there will be the planned projects to extract fossil fuels. And people could actually go to court and say, keep them in the ground, because bringing them out may actually lead to a lot of greenhouse gas emission. Climate change litigation can also be with regard to failure to adapt and impacts of adaptation, or it could relate to climate disclosures, whether they've been made or not, and greenwashing, where people make their activities look like they are really pro-environment, but in actual fact, they are not. So when we talk about climate rights, I think in a lot of countries in the global south, climate change action will present as a reaction to threats to human rights to life, water, sanitation, food, health, housing, etc. So states as duty bearers have an obligation to prevent foreseeable adverse effects of climate change, and also ensure that those that are affected, particularly the vulnerable ones, have access to effective remedies and means of adaptation that actually give them dignity. So when these issues come before court, they will actually come as an attempt to enforce constitutional rights. And one example is an Indian case in court on its own motion versus the state of Himachal Pradesh and others, where India's National Green Tribunal principal judge in New Delhi invoked constitutional protection of the environment and ordered authorities to undertake measures to protect against environmental harms made more likely and extreme by climate change. Similarly, in Colombia, there is a decision C036/16, where the Colombian Constitutional Court struck down as unconstitutional statutory provisions that threatened high altitude ecosystems, declaring the provisions unconstitutional for violating the public's right to clean water. There will also be cases that come up asserting or establishing that climate change has impacts on international human rights. And in 2017, the Inter-American Court of Human Rights issued an advisory opinion in response to a request from Colombia, where the court concluded that the right to a healthy environment is a human right under the American Convention. And the opinion addressed climate change, acknowledging that climate change is widely understood to interfere with the enjoyment of human rights, and specifically stated that to respect and to ensure the rights to life and to personal integrity of the persons, states have the obligation to prevent significant environmental damage within or outside their territory, and must regulate, supervise, and monitor activities within their jurisdiction that could produce significant environmental damage. Another interesting case is in Pakistan, where women filed a petition arguing that government had not followed through on its Paris Agreement pledge to reduce greenhouse gas emissions, citing failure to permit any renewable energy projects over a period of 14 months preceding the petition. And noting that the disparate impact of climate change on women in Pakistan, they argued that the government has violated their constitutional right to a clean and healthy environment, life, and also the right to be free from discrimination on the basis of sex. Then cases also come to assert fundamental rights of nature. So many times we go to court as humans seeking to assert our rights in relation to nature, but there is the increasing recognition of the rights to nature. This is the age-old contest between anthropocentrism, where we argue for rights of nature because they make our lives more manageable, or ecocentrism, where nature has rights of its own and in its own standing. And here, the argument is that the existence of certain rights necessarily implies enforceable obligations on government, even without legislation or regulation, implicitly or explicitly extending those rights to climate justice rights. There is a case here from Colombia where the Center for Social Justice Studies sought to compel the government to restrain the mining and logging activities that threaten the ecological integrity of the Atrato River and the health of nearby indigenous communities. And in granting the plaintiff's request, the Colombian Constitutional Court noted that the relationship between the Constitution and the environment is dynamic and in constant evolution. And it described nature as a real subject of rights that must be recognized by the states and exercised under the protection of its legal representatives, such as, for example, by the communities that inhabit nature or that have a special relationship with it. Rights, I mean, the climate change litigation can also come as rights of future generations. And this has also arisen in, again, a Colombian case where the Supreme Court recognized that the constitutional rights to life, health, minimum subsistence, freedom, and human dignity were substantially linked to the environment and the ecosystem, and ordered the government to develop and implement a plan to halt deforestation. And again, in another case in Brazil, where 4 political parties filed an action alleging the government's failure to properly administer the Amazon Fund, which was a mechanism created to combat desertification. And they said that by disbanding the fund's technical committee and calculating, which was responsible for calculating deforestation, the government had failed its constitutional duty to preserve ecological processes and to protect the natural environment. And this case has not yet been determined, but in June of this year, the Supreme Court accepted the lawsuit and directed the government to provide information on how it managed the fund and activities related to the fund that have been implemented or suspended. There have also been cases brought on behalf of young persons. There's a case from South Korea where 30 youth activists filed a complaint in the South Korean Constitutional Court alleging that the nation's climate change law violates their rights to life and to a clean environment. And the plaintiffs particularly allege that South Korea's Framework Act on Low Carbon Green Growth commits to reducing annual nationwide greenhouse gases at a rate that is insufficient to keep global warming below 2 degrees Celsius. Again, in Peru, a group of Peruvian youth filed a suit in December 2019, alleging that their government's failure to prevent deforestation violates their right to enjoy a healthy environment and their rights to life, water, and health. And they sought an order requiring the government to implement policies to reach zero net deforestation in the Peruvian Amazon by 2025. The cases can also come to force domestic action, and I want to hasten this. And here, the one case I'd like to talk about is the one from Pakistan, where the citizens sued the government and administrative agencies for not protecting forests and laws designed to protect and restore forests. And the court agreed with them and ordered the applicable laws to be implemented in letter and spirit to plant, protect, and preserve the forest. Then there is the keeping fossil fuels in the ground. These come as challenges to extractive projects. And there have been a number of cases, one in Pakistan, where a 7-year-old girl brought a legal action against the government and the Sid province, challenging approval of a plan to develop coal fields. And in Kenya, we've had Save Lamu et al. Against the National Environment Management Authority and Amu Power Company, where the National Environment Tribunal invalidated the license granted to Amu Power Company for the construction of a coal-fired power plant. The tribunal found that the license was issued without proper and meaningful public participation in the process and ordered the power company to conduct a new environment impact assessment that complied with all applicable regulations and that would consider Kenya's Climate Change Act 2016, Energy Act 2019, and Natural Resources Classes and Transactions Subject to Ratification Act 2016. So in conclusion, countries in the Global South are seeking to have their governments take action to combat climate change through various channels. They could go through environmental assessment, where you're seeking to have better environment impact assessment or strategic environmental assessment or environmental and social impact assessment. It could also be through management planning or through enforcement of constitutionally protected rights, as we have seen in the cases. It can be through public participation, and it could also be through holding governments accountable for implementing, enforcing, and taking action to combat climate change. More litigation on climate change is expected from the Global South, But this is likely to present, as we have seen, through other pathways. And many challenges are likely to come to enforce domestic actions, or to get particular administrative action, or to challenge administrative actions. Thank you. And I'd like to get some reactions and questions.
Okay, all right. Thanks a lot, Patricia. That was really in-depth, but also at the same time quite incisive. I think there's potential in litigation in relation to righting the wrongs of climate change. And I'm really excited about some of these measures, especially those that seek to bring countries that are responsible for human-induced climate change at international tribunals. And I'd like to see how these principles develop. And there's a question here in the chat that will allow you to expand a little bit on that in relation to Africa. But first of all, let me invite Steve to ask his question. This is for the benefit of others that will be listening to the recorded part of this discussion. So Steve, if you're still on the call, may I please ask you to present your question to Professor Kameri-Mbote.
I think he has left the call.
Okay, all right. I'll ask the question because I think it's quite apt. And he asks, drawing a distinction between human rights as a tool for popular mobilization and relying on international law and international human rights law as it appears in the treaties. How can we use or how can we outline some of the limitations in this as an instrument of resistance and advocacy? Are there limitations in the frameworks presented by international law and international human rights law?
Thank you very much for the question. I think one of the important lessons in the movement for environmental law and even towards environmental rights was the use of human rights to get traction for the concerns that people had. So many people will talk about environmental rights as what generation human rights. And I think human rights appeal a lot as a popular tool, linking people's rights to human rights to the environment in which they live. But I think in that also lies a tension. And the tension is that if we promote environmental rights only to the extent that they benefit humans, and we know, actually one of the things that we know is that a lot of environmental change has been occasioned by human action. And the question then is, when there is a conflict, when, for instance, you may want to stop human activity for the environment, who is going to speak for the environment? And I have seen a lot of that, not in general human rights, especially in women's rights and environment, where people see them as competing variables. Because when you bring in environment, it's seen actually to steal the show. from women's rights and vice versa. So I think there is need, in my view, for more studies actually to look into the points of convergence rather than divergence. But the way in which environmental law has developed and human rights, international human rights law has developed, I don't think we have, as scholars, looked for the points of convergence as much. And these sometimes may lead us to dark alleys where we see tensions that need not be there.
There's another 3 questions, and for the sake of time, I'm going to give you a compound question that I think you could address, because these are all issues that are related to litigation in the larger sense. And Talash asks, given that Africa only emits about 4% of global emissions, whom should legal action about climate change on the continent be aimed at? So this is a legal but also very political question, but I think it's an important question for us as African climate lawyers, climate change lawyers to consider. And then related to that is a question from Christophe, who asks, at what point may African countries take legal action against the global north in relation to human rights violations emanating from climate change, from exhaustion of atmospheric space, and loss and damage from climate change, and all these other issues. Okay, and then finally, a question from Nicholas, and he asks what you consider to be the limits or the challenges of using litigation as a tool of advocacy in climate change. Quite different but related matters, and if you could deal with as many of those as possible, please.
Okay. I'd like to deal with the issue of whom Africa should direct their climate actions against, together with when Africa can take legal action against the global north. I think in Rio in 1992, these discussions were very rife. The actions, these issues, and the question of we emit so little. So why are we even in this discussion? But I think as more and more impacts of climate change have become localized, many people now begin to look at what agency do people have at the local level. As a person who's been in these debates for a long time, I think when countries own when they own their destiny, it helps them a lot more than looking at who is responsible. Because this is like the old age questions about Africa and other countries going against the colonial powers for what they meted against them. And I think if you look at the climate change regime, there is a lot of cooperation. That cooperation seems to be falling apart as we move to now telling countries take action. But I think what should happen is more cooperation than really confrontation, because it doesn't matter where the greenhouse gases are being emitted. And now we know that the temperature rises quite, it is not small. So we don't want to lose the partnerships, the cooperation, even, because there is a differential treatment. I know that my friend and colleague, Philippe, was here this morning, and I do hope that he talked about his pet subject, differential treatment. in international environmental law. And I think that is what we should be pushing, technology transfer, facilitating compliance with the different obligations. But I don't think that saying that we go against the North is going to help at this point where we are seeing, even in the global South, temperature is rising. And actually, the net countries in the North have been able to stabilize their greenhouse gas emissions as ours are on a growth trajectory. Nicholas, on the limits of litigation as a tool for advocacy, I think litigation always comes with the fact that if you lose, then, and especially within a climate change context, the loss has monumental impacts on something that affects not just this generation, but generations to come. Litigation is framed in very specific and wrapped up spaces. So it may not be the best strategy for looking at horizons going to the future. I want to stop there, Toko.
All right, Patricia, I would like to thank you for myself and also for our participants that you could take time off on what is a very busy day for you to join us. I think the insights you have shared are really crucial in this debate, and as always, it's awesome to listen to you talk about issues that matter to you so much. Thank you so much.
Thank you. My pleasure to be here, and hope we continue talking.
Yes, yes,
Okay.
Certainly.
Okay.
Okay. All right. Thank you.
Bye.
Bye-bye. Bye.